This Honorable Court of Tennessee is now in session.
Good afternoon. This is the April session of the Court of Criminal Appeals in Knoxville. The panel today is Judge Ross Dyer from Memphis, Judge Tim Easter from Franklin, and I am Norma McGee-Ogle, and I'm from Sevierville. I think both of you are very familiar with our rules regarding 20 minutes per side for argument, and Mr. Gully has let me know that he wants 5 minutes for rebuttal.
Yes, Your Honor.
You may begin, Mr. Gully.
Thank you, Your Honor. May it please the court, my name is Gerald Gully. I am the attorney on appeal for Mr. Eric Boyd in this appeal from his convictions in the criminal court for Knox County, Tennessee.
I think we forgot, excuse me, Mr. Gully, I think we forgot to let the clerk call the case. We've had some technical issues this afternoon.
Yes, and I apologize for the technical issues arising from my end, Your Honor. I'm sorry.
State of Tennessee versus Eric Boyd.
Thank you. Now you may.
Yes. Thank you, Your Honor. May it please the court, my name is Gerald Gully of the Knoxville Bar. I am representing Mr. Eric Boyd in this appeal from his convictions in the criminal court for Knox County, Tennessee. As I previously mentioned, I am reserving or wish to reserve 5 minutes for rebuttal. If it please the court, this case is another case in the long series, the sort of tortuous procedural history of these multiple convictions for the very tragic killing of 2 young adults in January of 2007. Most of the co-defendants were convicted initially in Knox County Criminal Court because of various issues related to the trial judge. These convictions were sent back, they were retried and reconvicted. Mr. Boyd was not tried initially in Knox County Criminal Court. He was tried in the United States District Court for the Eastern District of Tennessee, where he was convicted of being an accessory to the crimes for which his co-defendants were convicted, and also for misprision of a felony. Subsequently, he was charged by presentment with many crimes relating to the killing of these, the kidnapping, the rape, and the robbery of these 2 young persons, and he was convicted of those crimes in Knox County Criminal Court. Now, there are 4 issues that I have raised in this appeal on behalf of Mr. Boyd, and I wanted to sort of focus on a couple of them. I think certainly the 4th issue, the issue of cumulative error, is one that I don't need to spend a lot of time on. It's fairly self-evident and self-explanatory, and the court, I'm sure, is very familiar with the rule in State versus Hester regarding cumulative error. The 2 issues that I wanted to sort of take up my time with relate to the 3rd issue that I presented and the 1st issue. The 3rd issue relates to the sufficiency or the lack of sufficiency to support these convictions on the grounds that essentially Mr. Boyd's convictions were based upon the testimony of an accomplice, George Thomas, who was initially convicted with Mr. Davidson, Mr. Hobbins, and one of the other co-defendants. Mr. Thomas came to an understanding with the state of Tennessee and testified in great detail about Mr. Boyd and Mr. Boyd's purported activities relating to the crimes against these 2 young people. It is our position that the evidence is insufficient because, again, Mr. Thomas was a co-defendant, he was an accomplice, and the well-known rule is that you cannot convict a person based solely upon the uncorroborated testimony of a co-defendant or an accomplice. Now, I wanted to point out that Mr. Thomas testified at great length about the whereabouts on the nights, the days in question, with respect to what was going on in the house on Shipment Street and other activities specifically involving Mr. Newsom, who was taken out at one point, bound, taken to a railroad yard. He was shot 3 times, according to the testimony of Mr. Thomas. Although Mr. Thomas did not actually witness that, he simply heard 3 gunshots. He also testified as to a loud sound after Mr. Boyd had, according to his testimony, taken some gasoline, doused the body of Mr. Newsom, and set it aflame. Mr. Thomas also testified about certain things that Mr. Boyd did or didn't do at the house on Shipment Street regarding the other victim, Miss Christian. I wanted to point out that, again, Mr. Thomas is the only eyewitness who puts Mr. Boyd at the place of any of these crimes that he's charged with. None of the DNA, really, certainly none from the house or none from the clothes, none of the DNA linked Mr. Boyd to the house on Shipment Street. None of the fingerprints linked Mr. Boyd to any of the crimes charged. There was no physical evidence from the house on Shipment Street that linked Mr. Boyd to the crimes. There were inconclusive ballistics about the 2 bullets that were recovered from Mr. Newsom. Now, the state points out that there is testimony independent of Mr. Thomas, which provides corroborating evidence for all of these crimes. Specifically, the state points to the testimony from Ms. Mathis, I believe a cousin of Mr. Boyd, who testified about Mr. Boyd borrowing a white Pontiac Sunbird of hers for a couple of days during the week of the weekend in question, and then how she found, after the car was returned to her, a plastic baggie full of bullets that had bullets in it. There was also testimony that a gun holster found beneath the seat of, I believe, the passenger side, but found in the car had some DNA that was linked to Mr. Boyd. But I would respectfully suggest that this evidence or this testimony is insufficient to sustain the convictions based upon the testimony of Mr. Thomas. Certainly, what the state has cited in terms of State versus Shaw, which citing State versus Bigby, it says that corroborative evidence is sufficient if it tends to connect the defendant with the crime charged. Now, let me emphasize that, with the crime charged. The Shaw also goes on to say, again, quoting State versus Bigby, it is not necessary that the corroboration extend to every part of the accomplice's evidence, but it must extend to the crime charged. I would respectfully suggest that the evidence that the state has pointed to as corroborating the testimony of Mr. Thomas does not sufficiently extend to each and every crime charged. It may relate to or potentially corroborate some of the crimes that were committed with respect to Mr. Newsom. The state certainly makes the argument that the bullets found in the car could be corroborating evidence. In fact, there was testimony that the white Sunbird he borrowed from his cousin, Ms. Mathis, was present outside the Chipman Street house on the weekend in question, may provide corroborating evidence for some of the crimes, but not all of them. I also suggest that the evidence which the state points out as corroborating is not necessarily or does not provide corroboration with respect to the criminal responsibility charges under which Mr. Boyd was convicted. I don't think it provides evidence for encouragement of the principle, and certainly there is nothing that is corroborated beyond the mere presence of Mr. Boyd at the Chipman Street house on the weekend that these terrible events took place. So with that having been said, I would respectfully urge this court to reverse the convictions based on the lack of sufficiency of evidence. The other argument that I wanted to briefly address was the argument with respect to the trial court's decision not to change the venue of the trial, or also not to bring in a special jury veneer for this case. That is a remedy that the trial court recognized would be appropriate with respect to one of the co-defendants. I believe Mr. Cobbins made that motion, and that motion was granted, but it was not granted here. I have referred to the juror questionnaires, which were filed under seal, and the fact that many of the respondents, I think 80%, knew of the case. They had heard about the victims. Over 70% had heard of Mr. Boyd and his co-defendants. 79% had heard of this case. 66% had discussed the case. And many of those persons had, formed negative opinions, of the defendants, and including Mr. Boyd. There were comments in the juror questionnaire forms about, they deserve to die, an eye for an eye. They're all guilty, things like that. Now, certainly the state has cited authority, I believe, State versus Rogers, talking about, the Hoover factors, and there was authority that, basically mere excitement is not necessarily a grounds for setting aside a decision not to change the venue or to bring in a special veneer. I would point out, however, or respectfully suggest that this case is a little unique from many cases in which someone might be charged with a crime that has some sort of notoriety. I think the crime in Rogers may have been a crime involving a child abuse. But here we're dealing with a case that for a number of years, from 2007, up to the time that certainly the co-defendants were retried, 7 or 8 years, was at the forefront of the collective unconscious, if you will, of this community, of this county. Certainly the crimes that were committed were horrific in nature. No one disputes that. But it is precisely because of the horrific nature of these crimes and the ongoing saga, involving the original trial and the original trial judge, and the fact that this had to come back for retrial. This takes it out of the, if you want to call it, the garden variety excitement of the community, which is can serve as a basis for as a prerequisite for change of venue or bringing in a special veneer. This was more than mere excitement. This is a tragedy that consumed this community for nearly the course of a decade. And
Mr. Gully, will the record here demonstrate that your client used all of his challenges during the jury selection process?
I believe, as the state pointed out in its brief, that not all of the challenges were used, or certainly there is an argument that not all of those challenges were used, Your Honor.
Isn't that problematic to your argument here?
It certainly doesn't help it.
Okay.
But I would respectfully suggest that you don't necessarily need to get to that prong or to look at that because of the fact that the entire jury veneer from Knox County was, again, you have this collective unconscious regarding
That's not, I mean, I get your point, but that's not 100% accurate. I mean, they were clearly, based on the questionnaires, there were individuals who either didn't know anything about the case or hadn't formed an opinion of the case. I recognize the percentages you cite are over 50%, but it's not 100%. And
Yes, Your Honor.
so there is a portion of the jury pool that is not influenced in some form or fashion, whether it's either knowledge or even as far as drawing a conclusion. Additionally to that,
That's what they say.
Well,
That's
but
what they say, yes.
we have to take them at its face value. And then to Judge Easter's question, what, not only about the peremptory challenges, but what's the proof as far as, whether or not juror 89, who may have been the one who said an eye for an eye or whatever, made it onto the jury versus juror 75, who said they had, didn't know anything about the case, formed no opinion of the case. What's the makeup of the jury? The state makes it sound like the people who sat on the jury, regardless of whether you used your peremptory challenges or not, were, quote, fine, based on the jury questionnaires.
Yes, Your Honor. And I guess first, let me go back and just, again, suggest to the court that because of the unique circumstances of the crimes and the tortured procedural history, of this case, that there's going to be a tremendous spillover effect, in the jury pool. I know that there were some, as I recall, juror questionnaires, and this may have come out on voir dire, about persons who were not living in the community at the time that the crimes were committed and had moved to Knox County thereafter. But again, I guess my point is that the unique circumstances here, I think, should properly raise a concern of spillover effect. With respect to
Mr. Valley, the state, I think it's the state's brief that indicates that the defense did very limited questioning of the proposed jurors to
Yes,
bring
Your Honor.
out these kind of issues. Do you agree with that?
Well, I don't know that I would necessarily agree with that characterization as I understand it, but certainly, as the state correctly points out, I think the trial court, given the fact that you had the juror questionnaires, the inquiry that the trial court made, I don't know that it was necessary, for defense counsel, and that may be a tactical decision by defense counsel. I can't say, and it would be speculation on my part, I guess, to go beyond that, Your Honor. I'm sorry. So, again, I guess the main point, and I guess I'm not trying to sidestep Judge Dyer's question, is that the totality of the circumstances certainly would suggest that, notwithstanding the responses of the individual jurors and the juror questionnaires, there was the jury veneer was improperly tainted, to such a degree that no fair jury could be selected, irrespective of how many peremptory challenges remained or whether they were all used up. But the entire veneer was sufficiently tainted that the trial court's failure to bring in a special veneer, as it did with one of the other co-defendants, rises to an abuse of discretion. So at this point, that's basically all that I wanted to, I guess, bring to the court's attention, and I would rely on my brief for the remaining arguments that I've set forth on behalf of Mr. Boyd, Your Honors.
Mr. Gully, if I can ask you one more question, I want to go back to the sufficiency real quick, and the corroboration needed. So if an accomplice testifies under the theory of criminal responsibility, if accomplice testifies, this defendant was helping us do this, he helped us do that, he participated in this, he participated in that, and I at least have a witness who can put the defendant at the scene. If the law is corroboration, however slight, and we're talking about criminal responsibility, your client being there, borrowing a car, those types of things, isn't that enough? I mean, do I really have to have another person who's not an accomplice testify that your client somehow participated in the crime?
Your Honor, I guess my response is that the corroboration that is involved by, for example, the testimony about the car that was present, it's corroboration of presence. It's not corroboration of any of the crimes. And that's what you have to have the corroboration of, the specific crimes that are charged. At least that's what State versus Shaw, quoting Bigby, says. So the corroboration, I think, is insufficient to get, certainly with respect to the criminal responsibility. I think it's insufficient to sustain convictions on criminal responsibility theory simply based upon the evidence before the court and the testimony of Mr. Thomas.
So let me ask you this. So two individuals are driving around in a car. The driver, for whatever reason, stops the car, gets out, and shoots someone in a parking lot. They keep driving around, and they're seen by numerous people throughout the day driving around in that car. The driver ends up giving a statement and says, "Oh, we planned on it. And when we saw that certain individual in the parking lot, you know, my passenger said shoot him." Do we have to have another witness other than the driver testify that the passenger did more than ride around in the car with him all day in order to convict the passenger of a crime? Because I'm not sure that the case law agrees with you on that. I think the case law says, however slight, that that's sufficient to corroborate the proof.
Well, I guess, Your Honor, the language in Shaw, again, quoting Bigby, says that it has to tend to connect the defendant with the crime charged. I don't think that evidence merely establishing the presence of the defendant in that car in your hypothetical would be enough because, I mean, as we all know, mere presence is not grounds for conviction. So it may not be a satisfactory answer, but I think that's the best one I can give.
Okay.
If there are no further questions, Your Honor, I will turn it over to General Redding.
You have your 5 minutes rebuttal, Mr. Gully. General
Thank
Redding.
you, Your Honor.
May it please the court, Captain Redding on behalf of the state. I will take up the defendant's sufficiency argument.
We're having trouble hearing you again, Ms. Redding. If you could just speak up, maybe that will help.
Sure. I thought I could resolve it, but apparently not. A reasonable jury could have concluded that the state provided sufficient evidence to corroborate George Thomas's testimony implicating the defendant in the commission of the conviction offenses. Thomas testified that the defendant was driving a white Pontiac on the night of the offenses, that he was part of the group that brought the two victims into Davidson's home, and that he was at the home for several hours while Ms. Christian was confined to Davidson's bedroom. Ms. Mathis's testimony from federal court that she loaned the defendant her white Pontiac the weekend of the offenses corroborated Thomas's testimony, and Xavier Jenkins' testimony that he saw Mathis's Pontiac, which he identified in a photographic lineup, parked behind Ms. Christian's 4Runner at the residence on the night of the offense, also corroborated George Thomas's testimony. Jenkins' testimony puts the defendant at Davidson's house at 12:30 a.m. Ms. Christian's vehicle and the phone records, her phone records place her at the house at the same time, and the medical records show that Mr. Newsom was raped between 11:45 and 12:45 a.m. So taking Ms. Mathis's testimony, Mr. Jenkins' testimony, that is enough to corroborate George Thomas's testimony. And the corroborative evidence that establishes the defendant's identity can be direct or it can be entirely circumstantial, and it doesn't have to be adequate in and of itself to support a conviction. It's sufficient if it fairly and legitimately tends to connect the defendant with the commission of the crime charged. And whether there is sufficient corroboration is a question for the jury. And a reasonable jury could have found the state's proof, namely this evidence from Mathis and Jenkins, sufficient to connect the defendant to the commission of the charged offenses. And so when you look at the evidence viewed in the light most favorable to the state, the proof presented through Thomas and through the other witnesses is sufficient to show that the defendant acted with the requisite intent for conviction under a theory of criminal responsibility. Can the court hear me okay?
That's much better.
So the defendant was part of the group that returned to Davidson's house with Ms. Christian's vehicle, and they obviously blindfolded and restrained victims. George Thomas's testimony was that the defendant led Mr. Newsom into the house, or that he was present. He was kind of in charge of Mr. Newsom. The defendant was present in Davidson's 800 square foot house when the victims were raped. We know this from the timeline. Thomas's testimony was that the defendant led Mr. Newsom to the vehicle, drove him to the train tracks, shot him 3 times, and set his body on fire. And afterwards, that he came back to Davidson's house and told Davidson that's taken care of. When Cobbins, Thomas, and Coleman expressed a desire to leave after Mr. Newsom was killed, the defendant told them that they needed to wait and that let them finish what they were doing. The proof was from Mr. Thomas, but the proof from Mr. Thomas was that the defendant stayed at Davidson's house alone with the female victim while everybody else left the residence, that he spent approximately 4 hours in the residence when everyone returned, relaxing, despite knowing that the female victim was confined to the bedroom. And that the defendant also entered the bedroom where she was being confined at least once during the night. And finally, the proof from non-accomplices from Miss Lightfoot was that the defendant took Davidson to Lightfoot's apartment and spent the night with him there after Miss Christian's murder made the news, that he spent the day with Mr. Davidson at Lightfoot's apartment, even after Davidson's photograph appeared on the local news, and that he broke into the vacant house with Davidson so that they could hide. And a jury could reasonably infer from the evidence presented at trial that the defendant did act with the intent to promote or assist in the commission of all of the conviction offenses when he helped Davidson and Cobbins bring the victims back to Davidson's house. The jury could reasonably infer from the defendant's decision to remain at Davidson's house while the victims were being raped and from his decision to kill Mr. Newsom that he knowingly and voluntarily shared in the criminal intent of all of the conviction offenses and promoted their conviction. And while Mr. Davidson may have been alone when he killed the female victim, the facts show that the defendant was an active participant in the events that led to her death and was not merely present before or after the offense. The defendant's continued presence and support of the overall endeavor showed that he furnished substantial assistance in the commission of all of the conviction offenses. And that evidence is more than sufficient to sustain his convictions, even if not as a principal actor for the first-degree murder of Mr. Newsom, but it is more than sufficient to sustain his convictions under a theory of criminal responsibility. And he's not entitled to relief on his sufficiency claims. And if we turn to his venue argument, the defendant is not entitled to relief regarding the denial of a motion or change of venue. As an initial matter, the defendant's waived this claim. The defendant's raised no claims in his appellate brief regarding the jurors who actually sat at his trial. So yes, there may have been a lot of pre-trial publicity, but when the court considers whether a trial court improperly denied a motion for a change of venue, the question is whether the jurors who actually sat at the trial were biased or prejudiced against the defendant. The defendant's claim on appeal is just that the jury questionnaires show a significant portion of the jury veneer, 130-person jury veneer, was exposed to pre-trial publicity. And second, as Judge Easter recognized, the defendant did not exercise or exhaust all of his peremptory challenges. Each party in this case was given 12 peremptory challenges to use during voir dire, and only 8 strikes were used in total between both the state and the defendant. So we don't know how that broke down, but even if all 8 of those belonged to the defendant, he still had 4 left to use, so he did not exhaust it. And there is published precedent from this court holding that the defendant who hasn't used all of his preemptory challenges weighs an issue as to whether a change of venue should be granted on the basis of prejudicial pretrial publicity. Regardless of waiver, the defendants also failed to meet his burden of proof by demonstrating that the jurors who actually sat at his trial were biased or prejudiced against him. Looking at the record, the trial court carefully and meticulously orchestrated the jury selection process to ensure that the defendant received a fair trial. Obviously, the court was well aware of the background of these cases and the publicity and how this had captured the attention of Knox County for many years. And to that effect, each prospective juror completed a jury questionnaire before trial. Although some of the jurors who did sit at the defendant's trial indicated that they had heard about the case or about the defendant, none of them indicated that they had formed an opinion about the case that they couldn't set aside. And after the parties received the jury questionnaires, the defendant was then permitted to individually voir dire the prospective jurors who he believed may have had a problematic exposure to pretrial publicity. And only one of the individuals who was eventually seated as a juror at the defendant's trial was included in this pretrial individual voir dire, and he did not provide any, he said that he didn't have any opinion about the defendant's involvement. Basically didn't provide any information that was concerning. He was not excused for cause and was allowed to go on to the general voir dire. And the trial court did excuse 15 potential jurors for cause when those jurors indicated that they would have difficulty being impartial. But once the parties were allowed to proceed to general voir dire, there was really no more questioning about the pretrial publicity that had really been addressed in the questionnaires and at individual voir dire. And the defendant didn't renew his motion for a change of venue or special veneer at any point. And as I mentioned, none of the jurors who sat at the defendant's trial indicated on their jury questionnaire or during voir dire that they had an opinion of the case they couldn't set aside. All of the jurors said that they could give the defendant a fair and impartial trial. And the defendant has not directed this court to any specific portion of the record indicating that the jurors who actually sat at his trial were biased or prejudiced against him. And he's not entitled to relief simply because some of the jurors were exposed to the pretrial publicity.
Why do you grant a special jury in one defendant's case, but not in another defendant's case?
It's not clear from the record, but looking at the dates, it appeared Mr. Cobbins was the only defendant involved in this case who got a special veneer. He had a Davidson County jury that sat in Knox County, and his was the first to go to trial. He went to trial in, I believe, August 2009 for the first time. His trial was August 2009. So it was closest in time, but I'll note that none of the other defendants got a special veneer or received a grant on their motion for change of venue. So it could be the timing, but that's not really explained by the record.
Okay.
There are no further questions. I will rest on my brief as to the defendant's remaining claims and ask this court to affirm the judgment of the committee.
Thank you. Mr. Gully?
Yes, Your Honor, and I guess I really have no further argument in rebuttal, although I would, addressing the question, I guess, from Judge Dyer about Mr. Cobbins, and in reviewing the other cases of the co-defendants, I was sort of mystified why none of the other defendants asked for a special jury veneer. I don't know why Mr. Cobbins was the only one. So, but having said that, I have nothing further on rebuttal. And
Mr. Gully,
yes,
I have a question that perhaps I should have asked earlier, but I wanted to see if you came back to it. You have raised as one of your issues the use of the transcript by Ms. Mathis from the federal court. I mean, to me, it seems like the law is clear on this issue. Are you still pursuing that as an issue on appeal? Her testimony was given under oath, subject to cross-examination. Is there something I'm missing on that?
I hate getting asked these questions.
Well, then I apologize.
Well, I'm glad Judge Easter asked that question because I was a little bit confused about the way this issue was raised. And as he said, I wasn't going to ask about it, but since he has.
Sorry, Judge Ogle.
As I recall, Your Honor, the state initially asked to have the transcripts from the federal trial admitted into substantive evidence, and initially Judge McGee denied that request. And I guess there was some back and forth. There was a jury out voir dire of Ms. Mathis, and she just kept saying, I don't remember. All I did was memorize what they wrote out for me to testify about at the federal trial. And I think after the jury out hearing, Judge McGee decided that yes, it would be appropriate to have the testimony admitted, and they did a question and answer with someone to get that testimony in. Again, I hate being put on the spot with these kinds of questions. I do think certainly the argument presented by the state on this issue, the law seems to be compelling. So I guess that's as far as I would feel comfortable in going.
I understand. Thank you.
And then, yes, Your Honor.
Any other questions? Ms. Kraft, I believe that will conclude the arguments on this case, and court is ready to recess.
This Honorable Court of Tennessee is now in recess.